There's been a remarkable court decision in Texas enjoining or blocking a new state law which sought to allow Texans to participate on the virtual public square free from Silicon Valley censorship. I'm going to attempt to deliver a short summary of the law here. For the full opinion and all of the court's reasoning, please see the document link in the description below. The new Texas state law, HB 20, prohibits large social media platforms from censoring a user based on the user's viewpoint. Specifically, the new law makes it unlawful for a social media platform to censor a user's expression, or a user's ability to receive the expression of another person, based on 1, the viewpoint of the user or another person, 2, the viewpoint represented in the user's expression, or 3, a user's geographic location in this state or any part of this state. Under the law, social media platforms may only moderate content on a referral from law enforcement or when the content, quote, directly incites criminal activity or consists of specific threats of violence targeted against specific persons or groups, including all the normal protected classes, but adding peace officers and judges. There are some other requirements in Section 2 of HB 20, which I'll put on the screen here. If a user believes a platform has improperly censored their viewpoint, the user can sue the platform, which may be enjoined, and the user may obtain attorney's fees. Plaintiffs bring several claims against the state, and the court focuses on plaintiffs' claim that HB 20 violates the First Amendment. To succeed, the plaintiff's NetChoice must show that HB 20 compels private social media platforms to, quote, disseminate third-party content and interferes with their editorial discretion over their platforms. The parties dispute whether social media platforms are more akin to newspapers that engage in substantial editorial discretion and therefore are entitled to a higher level of protection for their speech, or a common carrier that acts as a passive conduit for content posted by users and therefore are entitled to a lower level of protection, if any. Plaintiffs urge the court to view social media platforms as having editorial discretion to moderate content, and the state advocates that social media platforms act as common carriers that may be compelled by the government to publish speech that is objectionable. The court begins by citing to 3 Supreme Court cases that stand for the rights of private parties to moderate content disseminated on their platforms under the First Amendment. You can look these up if you want to see more details. In Miami Herald Publishing Company versus Tornillo, the court struck down a Florida law that required newspapers to print a political candidate's reply if the newspaper had previously assailed her character or official record. In Hurley versus Irish American LGBT, the Supreme Court held that a private parade association could exclude a parade float from their parade without being compelled by a Massachusetts statute to do otherwise. And in PG&E versus the California Public Utilities Commission, the Supreme Court ruled that California could not require a private utility company to include a third party's newsletters when it sent bills to customers. These holdings, the court said, stand for the general proposition that private companies that use editorial judgment to choose whether to publish content, and if they do publish content, use editorial judgment to choose what they want to publish, they cannot be compelled by the government to publish other content. Such editorial discretion is protected from government-compelled speech, says the court. Addressing the state's argument that social media platforms are common carriers, the court explains that they are not. Equal access obligations have long been imposed on telephone companies, railroads, and postal services without raising any First Amendment issues. But unlike broadband providers and telephone companies, social media platforms are not engaged in indiscriminate, neutral transmission of any and all users' speech. Social media platforms routinely manage content, allowing most, banning some, arranging content in ways intended to make it more useful or desirable for others, sometimes adding their own content. Making those decisions entails some level of editorial discretion, even if portions of those tasks are carried out by software code. Indeed, HB 20 recognizes that social media platforms, quote, 1. Curate and target content to users. 2. Place and promote content, services, and products, including their own content, services, and products. 3. Moderate content. And 4. Use search, ranking, or other algorithms or procedures that determine results on the platform. The court finds that HB 20 prohibits social media platforms from moderating content based on viewpoint. Viewpoint-based restrictions imposed by the government violate the First Amendment, which says that Congress shall make no law abridging the freedom of speech. It's important to understand who is doing the restricting. If the government restricts a private party, that's unconstitutional. But if a private party is restricting viewpoints on its own platform, that's not covered by the First Amendment. Texas counters that HB 20 does not prohibit content moderation, that it allows content moderation so long as entire categories of speech are banned, as opposed to banning users' viewpoints within categories of speech. Plaintiffs point out the fallacy in the state's assertion with an example, a video of Adolf Hitler making a speech. In one context, the viewpoint promotes Nazism, and the platform should be able to moderate that content. And in another context, the viewpoint is pointing out the atrocities of the Holocaust, and a platform should be able to disseminate that content. HB 20 seems to place the social media platforms in the untenable position of choosing, for example, to either promote Nazism against its wishes or ban Nazism as a content category. HB 20's prohibitions on censorship and constraints on how social media platforms disseminate content, therefore, violate the First Amendment. The platforms have policies against content that express a viewpoint, and disallowing them from applying their policies requires platforms to alter the expressive content of their message. Furthermore, the threat of lawsuits for violating HB 20 chills the social media platform's speech rights. HB 20 broadly prohibits content moderation based on viewpoint, authorizing the Texas Attorney General to sue for violations and even potential violations of HB 20's censorship restrictions. NetChoice explained that the threat of myriad lawsuits based on individual examples of content moderation threaten and chill the broad application of those content moderation policies, and thus HB 20's anti-moderation provisions interfere with plaintiffs' policies and practices. Using YouTube as an example, hate speech is necessarily viewpoint-based, as abhorrent as those viewpoints may be, and removing such hate speech and assessing penalties against users for submitting that content is illegal censorship, as defined by HB 20. The court spends the next 10 pages of the opinion further finding that HB 20 burdens social media platforms' editorial discretion, that it discriminates based on content and speaker, that it is unconstitutionally vague, and that it does not survive strict constitutional scrutiny or even intermediate constitutional scrutiny. For more details on the reasoning behind this decision, please read the document for yourself. I've put a link in the description. Plaintiffs point out that the state could have created its own unmoderated platform, but likely did not because the state's true interest is divulged by statements made by legislators and Governor Abbott. The state is concerned with West Coast oligarchs and the dangerous movement by social media companies to silence conservative viewpoints and ideas. I've always liked this idea as a thought experiment. If government officials are so concerned with the viewpoints of private companies, legislators could simply enact a law creating a social media platform of their own. This government-sponsored social media platform would fall firmly within the protection of the First Amendment. The government could not make laws abridging the freedom of speech on its own government-based platform. But my prediction is that this will never happen, because then the government would be required to host literally all speech that falls short of the Brandenburg line, the shouting fire in a crowded theater line, which only allows the government to limit speech that incites imminent lawless action. All other speech would have to be allowed. I predict that such a platform would quickly fall into unusable and unmaintainable chaos, serving only the interests of the lowest common denominator. Such a platform would quickly fall to the trolls. The court concludes by granting plaintiffs' motion for a preliminary injunction. The preliminary injunction prohibits the enforcement of HB 20 during the pendency of the litigation. From here, the lawsuit will continue, the parties will discover relevant evidence, and make their arguments in either a summary judgment motion or a trial before a judge or jury. But the granting of a preliminary injunction requires the moving party, plaintiffs here, to show a likelihood of success on the merits of the case, which gives me confidence that the state of Texas will not be allowed to implement its social media anti-moderation bill. I can confidently say that HB 20 is likely dead in the water. Of course, there is the potential for an appeal by the state of Texas, and I fully expect that the state will appeal, but I have serious doubts that any court will rule in favor of compelling the speech of a private party. Oh, and notably absent from the court's decision is any reliance on Section 230 of the Communications Decency Act. Let me know what you think in the comments below. Thanks for watching. Special thanks to our top supporters in December: John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Torpedan, ShadowTycho, Earthbound Star, PureMagma, Drew Hart, TechTechPotato, Eric Tams, and the Blood-Soaked Survivors. You can support Lawful Masses on patreon.com/ljfrench, sponsors.com/law, through YouTube membership, and through Floatplane subscriptions. Join me for our weekly live production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week and a great holiday. I love you all. Bye.